now we have our third panel, which is so far advanced and so ahead of the conversation and indeed the schedule, they've already seated themselves on the panel, which is excellent. The panel is freedom to versus freedom from. And of course, the focus this year is on a range of freedoms, some of which have already come up today. Freedom of the press, freedom of speech, freedom of religion. And there have been many questions around all of these things that have been swirling around this year with the Folau controversy, which is not about to go away any day soon. There's also questions around balancing national security and privacy with some of our most fundamental freedoms. So to host this discussion on some of these pressing human rights issues of our time is constitutional law expert, Scientia, is that how you pronounce it? No, tell me, I need to get these things right. Oh, Scientia, that sounds Latin. Scientia Professor George Williams, AO, Dean of the Faculty of Law at the University of New South Wales, and let's give him a welcoming hand. He's done so much work in this area for so many years. Thank you, George. And he's joined by award-winning human rights advocate and lawyer and Drum regular panellist, who I'm extremely fond of for how incredibly incisive she is always, Nyadol Nyuon. Welcome to you. And former Age Discrimination Commission and Disability Commissioner at the Human Rights Commission, and many, many other things, including former formidable female cabinet minister. And I hate to keep saying it, actually I don't, I like to keep saying it. She too is a Drum regular, and I love her dearly for it. And sorry, I almost skipped you at the end there. Chair of the Board of the Human Rights Law Centre and Deputy Chancellor of the University of Adelaide, the very distinguished and accomplished Honourable Catherine Branson, AC, QC. Over to you, George.
So thanks very much, Julia. This is one of those hard sessions for which there are no easy answers. How we weigh up and how we deal with conflicts between different human rights, particularly in a country like Australia, which is unique in not having any form of National Bill of Rights or Human Rights Act. So we're going to ask those questions. How should we as a society resolve these differences? How do we do it now? How can we do it better? And how do we do so with a view to some really pertinent examples in our community today? So I'm going to ask each of our panellists just to start for a few minutes to talk a little bit from their perspective and their experience. I'll then ask some questions, and then I'm looking forward to seeing what's on the Slido. So get your questions ready, and I'll try and get as many of those as possible as well to our panel. Susan, would you like to kick us off?
I would. Thanks, George, Nyadol, Kathy. Friends, I would like to start by acknowledging that we're meeting on the land of the Gadigal of the Eora, and I express my respect for their elders past, present and emerging. And I have to say, I always get a little bit of thrill talking about the Gadigal because I was born in Maroubra and live in Coogee, so I'm a bit of a Gadigal adoptee person myself. Now, the way we've protected rights in the absence of a Human Rights Act or Charter, as George and I know, since we spent a few years of our life unsuccessfully trying to achieve one, is really, one of the main ways is through our 4 pieces of anti-discrimination legislation. The first was the Racial Discrimination Act, 1975. The second was the Sex Discrimination Act, 1984, my legacy. The next was the Disability Discrimination Act, 1992, and then we had the Age Discrimination Act in 2004. They are the 4 pieces. And those, if people wanted to bring complaints that their rights under any of those were violated, they could do so, and sometimes they did them intersectionally, like an older lady of, say, Indian heritage might have a race complaint in employment, but she might also feel it was race discrimination. And so those matters could be dealt with and have been through the excellent complaints handling mechanism of the Human Rights Commission. But now we are contemplating a 5th anti-discrimination law, an anti-religious discrimination bill, a draft bill at this stage. Will that fit as in that interdisciplinary way with the others as I've described the first four did, perhaps not. Now, I'd like to do a little bit of ancient history and talk about how we ended up balancing rights in the Sex Discrimination Act, 1984. Now, the purpose of that act, as you probably all know, and some of you have probably practiced, was to make unlawful discrimination on the basis of sex, marital status, or pregnancy in those areas generally protected by our anti-discrimination laws, education, goods and services, so on and so, banking, finance, so on and so forth. Now, we started from the position that we wanted to outlaw it was discrimination against women, although it was gender discrimination. And they were all areas that affected the capacity of a woman to have economic independence, to have a job, to have training, to have education, to get promotion, to rent accommodation, to, if they happen to have had a job, get a mortgage, to buy a house. None of those things were available to women, or did not have to be available to women. So it started like that. We didn't start with the idea of having exceptions or exemptions. We just said, no, there should not be discrimination in these areas. As we proceeded through the debate, which I can tell, some of you will remember, but a lot of you probably weren't even born, was a very contentious debate, extremely contentious, opposed by conservative forces all around, and really opposed on the basis that if women got these protections, who knows where the world would end. They'd be taking our jobs, you know, they'd be earning more than us, children would be delinquents, all of that. That all went on. Sounds hilarious now, it was pretty horrible at the time. So in the course of that very long and contentious debate, I realised, having the carriage of the bill, that we had to get the bill through the Senate, we had to accommodate amendments. And the most significant one brought to us by the opposition, was then the Liberal Party, was that we needed to give an exemption to church-based schools so that they could employ teachers of their faith in those schools without drawing upon themselves a complaint of discrimination. Now, we ultimately decided that was quite reasonable, and that exemption went in. At the same time, it was understood too that church-based schools, which were established and funded by the Commonwealth and state for the purpose of providing children with the religious education of their parents' choice, they could give enrolment priority to children from that faith. Okay. Now, you might be interested to know that the main diversion from Christian values and behaviour that the church school spokespeople were worried about were unmarried mothers, divorced people, or a male or female teacher living with someone they weren't married to. They were the main moral hazards of the time. How times change. Anyway, when we introduced those exemptions, we saw them as actually quite reasonable. Yes, if you're running a church school, the teachers, yeah. We saw them as reasonable, but we also saw them as limited, limited and specific, not a general right for people of religious, from people from churches to decide they didn't have to abide by any discrimination law. Now we are in a different climate at the moment, but that was how we got to have that law with those exemptions. And I must say, that Sex Discrimination Act has been amended many times, but the exemptions have stayed.
Thank you, Susan. Kathy.
Thanks, George. I join with Susan in acknowledging that we're on the land of the Gadigal people of the Eora Nation, and pay my respects to them and say how pleased I am to see a number of First Nations people with us today. There are only two ideas I thought I'd float early. The first is that it seems to me that respect for human rights is actually it's an attitude of mind. Laws are helpful. Without laws, attitudes are difficult to change. I mean, remembering Susan's very important legislation. People say laws don't change attitudes. They do. I mean, that law dramatically changed the attitude of Australians towards the rights of women. But in reality, if people's minds don't accept you know, that a fair go for everybody, the sort of egalitarian ideas that are so basic to early Australia and that we're losing are not fundamentally important, that it's not fundamentally important that the vulnerable are protected, you know, that you don't have children abused in places of detention, that our Indigenous youth can't get proper education, things of this kind, then we've lost touch with human rights. You know, a respect for rights is the attitude you bring to what you think makes your society a good one. So laws are important, I don't want to suggest otherwise, but I think what we aim for in the long run is an Australian people for whom the sense of what is fair, what is just, what's egalitarian is what we're fighting for. And it's in that context that I say, being one of those people somewhat scarred by the last consultation around human rights, and may I interpolate that I want to congratulate Ros on starting this new conversation, which I think is enormously important. But at the end of the day, what I felt went wrong with the last consultation was ultimately, and I can say it because I am one of these people, the views of lawyers and the views of politicians, most of whom were lawyers, were privileged over the views of other people. I think, you know, an event like today, where we're hearing from a wide range of people, is the way to start addressing that problem. It seems to me, wondering whether unelected judges will end up being too powerful and things of that kind is a bit like saying, whatever code you follow, I don't want my kids playing football because I'm worried about the quality of the umpire. I mean, it looks silly in that context. It was silly in the human rights context. Human rights are important not because protection for them empowers judges, but because it involves the elderly being able to say, I've got a case for decent treatment in my healthcare system. It enables a kid to say, I've got a right to go to a school where the facilities are decent. You know, it enables a sick person in the country to say, you know, I should have access to the sort of healthcare I need that means I can live as long as somebody who lives in the city. Those are the things that are important. And I think one of the importance is to find ways that people can hear from those who are the ones that need the protections that human rights might provide. One of the great privileges I experienced when I was president of the Australian Human Rights Commission was that in that period of the consultation led by Father Frank Brennan, I had an excuse to go out and speak to all manner of people. I spoke to people of different faiths, different ethnicities. I spoke to victims of violence. You know, I spoke to people who were homeless. I spoke to people who've just got out of prison. I spoke to a wide range of people, and it significantly shifted my view about whether Australia needed human rights protections. They needed them because too many people didn't take for granted that their privileges were that they were privileged, they were not a right, and that were truly vulnerable people in our country that need a fairer go than they're getting. Thank you.
Thank you. Nyadol.
Well, I too would like to start by acknowledging the traditional owners of this land and pay my respects to their elders past and present, and also acknowledge the women on this panel. Not to say it as a throwaway comment, you know, you are both really accomplished women, and I believe that as a young woman, if I can consider myself such, that I have benefited from the work that you've done and the path that you've made. So I want to acknowledge that too.
How gracious. Thank you.
So I've entered, I suppose, this debate about right and balancing right from two perspectives. The first is to look at it more on the impact it has on those that are on the edges of those conversations. And the second part of it is to look at the laws, the discriminatory law, but also the conversations we have, not in isolation, but how they also connect to the current political environment we have, some historical understanding of both racism and colonialism, and how those deeper issues plays a role when we are talking about rights and freedoms. So I'll go back to talking about the impact. During the debate, the same-sex marriage debate, I remember going through Twitter and finding someone tweeted and said that I think there was a back and forth going about the importance of having that debate, and the person that wrote the tweet said, I was a pallbearer for one person who could not take in any more of this debate. And it shows that sometimes these general debates that we have about people's freedoms and people's rights to say certain things have a tremendous impact on other people's lives. And so we cannot just see laws in isolation as only protecting certain rights or certain privileges. But there are those, particularly those who are in minority groups, that don't have the same platform, I suppose, to engage in the debate in the first place. They don't have the political capital to be able to challenge and push back. So the platform starts off, the marketplace of ideas start off already against them. And so this became quite apparent when we were launched a campaign a while back to have the Australian government stop a guy called Gavin McInnes from coming to Australia. Gavin McInnes had started an organization called the Proud Boys in the United States, and they had engaged in extensive violence to the point that in the town of Portland, there were considerations of introducing laws to deal with some of the violence that the Proud Boys has brought in. He had said things that his group was there to punch people, choke them, and use really aggressive language and describe his group as in a nutshell, they will kill you. He was misogynistic, he was racist, based on the content of what he has produced. And a group of us worked together to try and start a petition and to try and get the minister at the time, Minister Coleman, I'm not sure whether he's still the minister now, to try and revoke his visa from coming to Australia. And so the first challenge we faced, of course, was the fact that this was cast as a free speech issue. He has a right to free speech, and therefore we should be, as a society, we should be willing to listen to ideas from people. And I remember saying that this was actually not about free speech. This was more about hate speech and the incitement of violence. And trying to insist that to insist on such a distinction was not anti-free speech, it was actually for free speech. Because part of what it did is that it made it clear to us, at least as a society, where we draw the line when things cross the bound. And it was quite a hard argument to make because Australia is a liberal democracy, and even though we don't have a charter of rights, we still fundamentally believe in these freedoms. And I think a lot of us share those beliefs, and I do too. I am happy for someone to not like me for the color of my, not happy maybe, but I'm okay with someone not liking me for the color of my skin. They don't have to. But when that person wants to go to public and campaign and get the political wheels moving so that such legislation or his ideas become public policy, then I think that's the point where we begin to have a serious conversation about where that debates would end. And some people might think that, well, that's actually extreme. You just have to look at the United States currently to see that things that seem extreme just 2 weeks ago don't seem extreme after a tweet by the President of the United States, unfortunately. And, and that indeed policies that we think will never be initiated, like the separations of children from their parents in the United States, can indeed be put into place. And in Australia, we have our own draconian laws against when it comes to settlement of refugees and asylum seekers. But so that was one of the main at least in my experience, that was one of the areas where it became quite clear to me that the debate about free speech really sometimes doesn't take into account the people that are much more impacted by the speech itself. Now, when it comes to hate speech and things like racism, beside the offense that you would take, which has been one of the main, I suppose, argument advanced by people who support a much more broader interpretation of free speech, is that it's not offense that is the issue. Racism does have health impact, real health impact on the lives of people. And in fact, I think it was doctors in the United States recently released a report talking about the impact of racism, the long-term impact of racism and racist policies on children. So I think part of the debate that we have here is to try and construct the debate in a much more broader sense, to say it's not about offense, it's about health and public health sometimes. There's also the second issue that arises when speech is sort of put as if it's just about offences, you don't take into account the serious physical violence that sometimes arises as a result of what has been termed controversial speakers coming to Australia. And there have been a number of them coming to Australia, and unfortunately, which will come to my second point, I'll try and wrap up quickly, which would connect the different parts. We've had media, certain media outlets that have provided them with significant platforms to spread their ideas, particularly when some of these people have actually been banned from other countries, Western countries like Australia. And one incident resulted into a group of young people being bashed after an event had concluded and taking up significant police resources. But besides, I suppose, the impact, another frustration I've had is that people tend to seem to take the free speech debate in an isolated view. But what I have discovered, at least in my experience, is that there are levels of links between people like McGuinness, the media, the political environment that we are in, and the laws themselves. So with McGuinness, one of the things he did was to, of course, insist that this was just speech and it was just comedy. And then, of course, he got significant backing from certain media outlets that then said that it was, we should be allowed to have speech like this and debates like this in Australia, even though at that stage we were saying this is not, in fact, a free speech issue, is a hate speech issue. And there was significant support even from a former politician who said that McGuinness should be allowed to come in. It also took significant pressure to even convince the immigration department that this was someone that was actually a danger to the Australian society. We had over 80,000 people sign a petition. We constantly were calling his office to try and get a reply from them. Eventually the visa was cancelled, luckily, but it took significant pressure to get that. And in all that, I remember a quote from Gavin McGuinness himself, where he said, "It is our job to beat the hell out of people and for the authority to turn a blind eye." It made me realize that people like McGuinness really understood something that maybe the broader community didn't understand, that they had the tactical backing, even if it wasn't intentional, of the way of certain institutions and certain political powers. They knew that in certain areas of the media, they will get the backing, and they knew that even in the political sphere itself, there would be some people that would turn a blind eye to what they were saying. And so that clearly, at least to me, demonstrated the links and the gaps in which people like McGuinness could get away with what they said. Because I can assure you in this room, and I can say this with tremendous confidence, had the things that Gavin McGuinness said been said by a brown Muslim man, I would have not need an 80,000 petition to not get him to come here. And that says something.
So before I go to the audience questions on Slido, and please vote now if you'd like to indicate which questions you'd like to hear. A few questions for the panel. Firstly, Susan, if we look at how Australia has resolved these issues of competing rights, and these are perennial issues that go across decades, a primary answer has been anti-discrimination legislation.
Yes.
So the problem of the rights of women, we've got the Sex Discrimination Act. The problem of religious institutions and religious freedom, the answer, it seems, is a Religious Discrimination Act. And there's something quite striking about that in Australia, which is very different to the experience of other countries. I was intrigued in your remarks, you suggested perhaps there's not room for a fifth, that perhaps, at least in this area, that is it because we've reached the end of the road with anti-discrimination legislation being the solution, or, I mean, how do you see the path forward now, given the body of law that we have built in this area?
Well, I think, of course, there is room for a fifth, but the distinction I draw between the draft Religious Discrimination Bill as we have seen it and the 4 already enacted is that under those 4, you can interact with them. I gave the example. An older woman could bring a complaint in her employment that might have partly to do with her age, partly her ethnicity. She may have a disability. So they can work together as well as working separately. But with the religious freedom and religious discrimination ideas that are at the bottom of the 3 bills that the government's put out in draft form, you will get a conflict, so that the issue has been a number of church schools, for example, don't want to have to, they don't want to have gay teachers or gay students, but they don't even seem to want a recognition that...
Because it throws up what intractable
It throws
problems.
up conflicts that the other 4 don't, you know. You can be a person with disability and a woman and feel that your rights have been violated through some combination of those things. But if you are a gay person teaching in a school, or even working for a church-based charity, it seems that some of the advocates for the 5th strand are saying you don't have any rights. And I think it makes it a different kind of provision. It could be more limited, and I know the Human Rights Commission's put in a very detailed submission on the draft bills and made some very sensible proposed amendments, which would take away some of these irreconcilable conflicts. But the other thing I do have to say is that now that we've got to the stage of looking at protecting broader freedoms, and we've got the freedom of speech thing, the freedom of press, all that going, we would really best achieve a balance of all of our fundamental rights by a charter or a National Human Rights Act. So that, I feel in that sense the time now has really come. But it would be possible to have that 5th piece of legislation, but it needs to be drafted so that it's not actually in irreconcilable conflict with the others.
Oh, look, you've convinced me about the need for a Charter of Rights. So,
Oh, that's a first.
as a Cathy, my question's about how we resolve these differences in Australia between competing rights. And anti-discrimination legislation is, of course, one way we do so. I'm wondering if you can tell us how otherwise institutions are able to resolve these differences, and whether it's an adequate way of ensuring that where there's a conflict between press freedom and national security, or indeed any other list of things we might come up with, that we have the mechanisms to actually get a just and fair outcome.
Look, it is always a difficult question, and I think in a democratic country like Australia, ultimately our democratically elected representatives are going to have to debate those balances out. But you would hope, they would inform themselves by speaking, in very thoughtful and receptive ways to the people who will be most impacted by the decisions that they're making. And I would think for myself that where we identify rights that are fundamental because they're inherent to the dignity of individuals and their capacity to live free and equal lives, that any restrictions on those would be the narrowest possible. One right really can't be privileged over another, except in the narrowest of circumstances where it's required. So, of course, I do accept that something like a faith-based organisation, where there are beliefs that are fundamental to that faith. People, of course, can believe whatever they wish. It's only when they come to making public demonstrations of their beliefs that the public interest arises. But I think it should be as narrow as possible. And the second is that there should be integrity in the system. So I raise the church school because it's one that's always raised as the issue of debate. If a school were to say, look, it's fundamental to the school that we're running that people share the tenets of our faith, then I think they should be open to investigation about whether that's right, whether they are doing that. So if you had a faith-based school that said we want all our teachers to adhere to the tenets of our faith, but say it was a Christian school, but you discovered that the science master was Jewish because there was an experience that high marks were achieved by having a particular science master, then immediately they've demonstrated that it's not fundamental to the running of their school that everybody share the tenets of their faith. So I think there ought to be some, if you claimed that sort of immunity, then I think there should be some capacity to test whether that's genuinely the way you're running your school, or if it's only what you say when it suits you, but you're willing to break the rules because you, for example, can then get kids with the highest maths marks, or you can run a rugby team that wins all of the matches if you bring in someone with an entirely different faith to coach the rugby team. But I think my broad principle is one of coherence, narrowness of exceptions, but listening very much to the communities that are involved.
Thank you. And Nyadol, you talked about people on the edges of these conversations and often how they're not involved in resolving these questions. Do you have any ideas for ways that could happen? How in Australia could we actually ensure that the people who are most affected by the debate about vilification laws and freedom of speech, for example, how can they have a say to make sure that they're part of actually resolving solutions about those competing interests?
I think in Australia we continuously have conversations about diversity in the media, diversity in our politics, but I'm not sure how far we're moving with that. I think we're making some progress in certain areas when it comes to diversity, gender diversity, and maybe that's an easier conversation to have. But I think there is significantly more to be done when it comes to racial diversity in certain places. And maybe the reasons why we, at least in my experience, we're not very comfortable with the R word is because we haven't yet resolved issues with our Indigenous community. And so talking about race is really difficult conversations for the nature of our politics itself. I mean, we're talking about whether Indigenous people should even be recognized in the Constitution. And I think that's why people try to move around the conversation about race. And most of the time when you go to these spaces and they talk about diversity, they are generally talking about gender diversity. And so it's harder for even the more marginalized people to get a chance to speak. And it makes it difficult when so I suppose the institutions or the mechanisms that are supposed to offer us solutions no longer function as well, or as somehow. Maybe the best way to say it is this. When you look at our parliament currently, our federal parliament, is predominantly white and male. And I have nothing against white men at all. But it's just the fact, and also in our institutions, the power structure is generally quite dominated by white people and by male people. And so when we rely on such institutions in a very multicultural society to provide us with solutions to really complex issues, social issues, it's harder for them to come up with solutions when they themselves have an experience, don't have similar experience with the people that they're representing. But it's also just not a matter of individual representation. There's also the fact that in certain situations, the very institution, again, say the federal parliament, might not even be in sync with the general society in some topics. Look at climate change, for example. A lot of Australians believe in climate change. We don't have a national response to the issue of climate change. It's the same thing with same-sex marriage, where a majority of Australians, even before the election, the pandemic was done, supported same-sex marriage, but our politicians were still dragging their feet, the people in power still dragging their feet. And so it becomes really difficult when the institutions, the ultimate institution, at least in a democratic society, when it can't seem to offer solutions that take on the nuances of the citizens that they're serving. I think it makes it hard then how to reach those solutions.
Thank you. Now I'm going to go to questions from Slido, from the audience. And there's one that's been rocketing up the popularity stakes of the questions. And this says a live question from detained refugees. How can we get everyday Australians to hear us as marginalised people, to understand we aren't dangerous and question our detention? I don't know, Susan, whether you want to have a go at this one, a nice straightforward one to start?
Well, you see, I think the blockage to getting rid of that failed anti-human rights policy of the offshore detention is a lack of political courage. That's what I think it is. I don't think it's the community. We saw a lot of media coverage of that family from the Billawheeler community. Now, they had been welcomed into a small country town, not supposed to be the most sophisticated human rights conscious part of Australia, welcomed, loved and supported. It wasn't the people of Billawheeler who had difficulty with them. It was the government of the day, and not adequately challenged, I'm sorry to say, by the opposition of the day, about if they were allowed to stay, would that undermine our border protection policy? I think the problem is with our politicians on this particular issue, and I'm ashamed to say it as a former politician, but I really think it's not the community. Of course you might get, and you would know better than I, Nyadol, but you might get people saying, oh, there are too many refugees. Or, that's why we have traffic jams in the western suburbs of Sydney, apparently. It's because of, you know, migrants. And the people in offshore detention aren't even there driving up the Parramatta Road, but somehow they're getting the blame for it. But it's not, people say silly things and unhelpful things, but it's really, in the case of the treatment of refugees and asylum seekers, it is a failure of policy and it's a failure of political will, I'm sorry to say, on both sides of the parliament.
Thanks, Susan. So I'm pleased to say the next question could have come straight out of one of my constitutional law classes. I think we'll throw this one to Kathy, but if you need, Kathy, we can do this one jointly. We'll see how we go. Is the proportionality test about balancing limits on human rights too legalistic and a barrier to ordinary conversations with people?
Well, in one sense, of course, it is. It doesn't mean that it's not a good thing for lawyers to talk about or other experts in the field to talk about, but it is a barrier, I think, to engage talking with your neighbour over the back fence or engaging some teenager who comes to talk to you because they know you've got an interest in human rights. But the proportionality test is in its heart a quite simple thing. You know, is this a necessary thing to do? Would there be a less oppressive way to do it? Is the thing we say we're protecting worth protecting anyway? I mean, at the heart of the proportionality test are very simple, basic questions that we all ask all of the time. So it's a shorthand for lawyers. It's the jargon that lawyers use, and like other legal jargon, it, you know, cuts off most members of the community, but it doesn't mean the concepts behind it are not the right concepts. I think they are, and we need to talk about them.
Thanks. And I would say on that, when we were drafting the Victorian Charter, we built in a proportionality test in plain English. So in fact, lawyers did not need to use it. So public servants and the like. And this goes back to the earlier question about who should resolve these competing claims. Very often it will not be a lawyer, it'll be someone working in a commission, working in a department, working in a community agency. And so we need tools that are accessible and usable by them. And you know, proportionality as a concept, as you say, it's common sense, straightforward about reasonableness, but it's a barrier. Anything to do with jargon makes things harder.
It is, but it's a shorthand term. So of course lawyers use it. Instead of saying, is this necessary and is the right balance? And is it too severe for what we need? And all of the questions that are involved in proportionality, very handy for the lawyers to say, is this a proportionate response? And they know what it means. But the error is when you think everybody will understand what you mean. They very likely won't.
Thank you. So, Nyadol, I think the next question is for you. This is a question about how can we define the boundaries of hate speech in legislation. How can we have this discussion in a meaningful way as it seems so subjective and controversial?
I think there is grey areas where there's debate whether something is hate speech or not, but I would think that there are clear areas when it's clearly hate speech. You know, when you're spraying swastika on buildings, I would find it. I would argue that's objectively offensive to a group of people that have suffered a particular historical injury, a significant injury. And so I do think that part of the debate is sometimes it casts as if we cannot tell the difference. I think we can't. You know, there's definitely an area where we cannot, and that's the area where you might have to have a debate. For example, in my experience, there was the Milo Yiannopoulos incident, and Milo was another far-right figure engaged in really what I find offensive, you know. But at least in my view, I didn't think that was incitement of violence. And I thought that to then say that someone like him should not be allowed to come to the country wasn't quite clear. You know, I wouldn't welcome him for tea in my house, but he could go hang out with this group of people that he wanted to. But then you get to someone like Gavin McGuinness, who has established a gang which engaged in consistent pattern of violence And he's on record on video saying that they will bash people, they will choke them, that they should be shot, that he's from a group that is going to kill you in a nutshell. And I thought that's clear cut. That's someone who is inciting violence and in fact is backed by violent conduct.
And that's where you draw the line.
And then that's where I draw the line. I think when it's clearly inciting violence against a group of people, I think that's when we should, I think, intervene. That law should intervene. But I think it's different though for politicians. I don't think most politicians would be courageous enough to say that we should kick out. Well, maybe they are. Donald Trump is. We should keep out all Muslims. So. But I do think that when it comes to politicians and the way they run election campaigns, that it becomes really difficult to draw that line because they have significant power within a society, and as most minorities will tell you, at least Black and brown people, is that when you have election campaigns like the one we had in Victoria, which was a law and order campaign, which was an African gang campaign, it changed the way you experience being a citizen in that state or being a citizen. It changed the way you walk in public spaces. I was speaking to young people who didn't feel safe in taking public transport, women who were being abused and spat on the street, young people who were being called African gangs just because they were hanging out in groups of 3 or 4. Young people that were being kicked out of libraries because the rest of the community had to be made to feel okay because there had been an incident involving Black kids before. They were removed out of a library so that the rest of the community could be assured. They were not involved in the incident. They had nothing to do with it. But because of the color of their skin, they had to be removed so that the rest of, which made me question, where is their community? Which community are you protecting these children from? And if you are telling them that there is a community to be protected from you, where do they belong? I mean, what a heartless message to send to a group of young people just trying to study at a library. And so when politicians engage in this kind of conversation, it becomes tremendously impactful and sometimes in very negative ways. But it's a difficult debate to have because in a democratic society, you would expect that we are able to have these conversations. But when, like I said before, the people you're having these conversations on are not in the media, they don't have politicians in the same space backing them, they're literally shut out of a conversations that impact their day-to-day life. That makes it harder in those times.
Well, thank you. We've come to time, and that's a really appropriate moment to end on just the difficulties of actually balancing up these competing interests. I mean, as Nyadol said, on the one hand, you might draw the line when it comes to incitement to violence, but the problem is drawing it there. There are so many harms under that line that speech can do that, in fact, in many ways, the law is very ill-equipped to solve. It really gets back to the community aspects that we've talked about. So thank you. This has been a really interesting panel. I can't say we've got all of the answers out of this. This is an ongoing area, of course, for which there are no satisfactory answers. It's really how we as a community deal with these questions and strive towards just solutions. But if you can please put your hands together to again thank Susan, Kathy and Nyadol.